Sending cases to the Crown Court. The magistrates must officially send the case to the Crown Court, where the trial will be held at the Crown Court. The matter is moved to the Crown Court directly from the first court hearing at the Magistrates Trial regarding indictable crimes. This is provided for under S. 51 of the 1998 Crime and Disorder Act. Magistrates will hold a plea before the venue for triable-either-way offenses and, if the defendant pleads not guilty, a motive trial hearing. If it is agreed at this trial that the matter is to be heard in the Crown Court, then the magistrates will forward the argument to the Crown Court. 13.1.6 Committal for sentence. Magistrates can undertake to the Crown Court a defendant charged with a triable-either-way offense. Nevertheless, this will only take place if they feel that their abilities of punishment are insufficient after hearing the past history of the defendant at the end of a case. The magistrates may take the view that the crime, or the mixture of crimes, is so severe that a larger sentence should be levied than they have the authority to execute. For instances of violent or sexual crimes, judges may be convicted because they feel a long prison term is needed to protect the public from serious harm. The number of committals for penalty more than doubled after the implementation of plea before place. The magistrates send nearly 28,000 offenders each year to the Crown Court for sentencing. There are criticisms that judges commit too many defendants for sentence, as a significant percentage of those committed for sentence receive no more than the judge might have imposed on them. 13.1.7 The role of the clerk. Each magistrate bench is supported by a clerk, often known as a legal advisor. The oldest clerk in each trial must be at least 5 years practicing barrister or solicitor. The clerk's job is to direct the magistrates on civil, realistic, and procedural matters. The judge guarantees the court meets the correct procedure. At the conclusion of a trial, for example, it is the lawyer who will question the client if he pleads guilty or not. The clerk is not supposed to engage in the decision-making process. That's the job of the magistrates. That implies that when they leave the court at the end of a case to consider their verdict, the clerk should not retire with the justices. The senior clerk has been given greater powers to deal with routine matters that magistrates had to do previously. For example, now clerks can issue arrest warrants, extend police bail, adjourn criminal proceedings, where the defendant is on bail, and the bail terms are not changed, and conduct early administrative hearings. 13.2 Youth Courts. In the Youth Court, which is a division of the Magistrates Court, young offenders aged 10 to 17 are dealt with. It is not possible to charge children under the age of 10 with a criminal offense. There are some exceptional cases where young offenders can be brought to trial in the Crown Court. These are cases in which the defendant is charged with murder or homicide, rape, and dangerous driving, causing death. Additionally, in any case where they are charged with a serious offense, usually one that carries a maximum prison sentence of at least 14 years for an adult, it is possible for those aged 14 and over to be sent to the Crown Court for trial. The Youth Court sits confidential, with only those involved in the case allowed to enter the courtroom. Press members may be present, but they cannot publish any young offender's name or other information that could identify him, such as address or school. The magistrates in those courts who sit on the bench must have had special training in dealing with young offenders. At least one female magistrate must be on the bench, and one male magistrate. The court procedure is less formal than in adult courts, and the parents or guardians of any child under the age of 16 are required to be present for the trial. The court may also request parents of those 16 or 17 years old to attend. 13.3 Appeals from the Magistrates Court. There is a system of routes of appeal available from a magistrate's court decision. The route used will depend on whether the appeal is solely on a point of law, or on other grounds. The two routes of appeal are to Crown Court, or Divisional Court of Queen's Bench. 13.3.1 Appeals to the Crown Court. This is the normal appeal route and can only be accessed by the defense. If at the Magistrates Court, the defendant pleaded guilty, then he can only petition against the sentencing. If the defendant pleaded not guilty and was sentenced, then there may be an appeal of guilt and/or penalty. The defendant has an immediate right of appeal in both cases and does not need to be allowed to appeal. The trial is completely reheard by a judge and two magistrates at the Crown Court. We can come to the same conclusion as the magistrates and uphold the verdict, or they can opt not to prove the case and revoke the judgment. In some cases, they can change the judgment and consider the offender guilty of a lesser crime. Where the appeal is also against the sentence, the Crown Court can either confirm the sentence or increase or decrease the sentence. However, any increase in the case can only be up to the maximum powers of the magistrates. There have been approximately 13,500 appeals to the Crown Court each year over the last few years, and judicial statistics published by the Ministry of Justice show that the appeal is allowed in approximately less than half the cases. When it becomes evident that a point of law is to be determined, then the Crown Court may decide on that point of law, but there is the possibility of a further appeal by way of a case-stated appeal being brought before the Queen's Bench Divisional Court. 13.3.2 Case-stated appeals. These are appeals to the point of law that goes to the Divisional Court of Queen's Bench. This route of appeal may be used by both the prosecution and the defense, and it may be directly from the Magistrates Court, or after an appeal to the Crown Court. It is asked that the magistrates, or the Crown Court, state the case by setting out their findings of fact and their decision. Then the appeal is argued on the basis of what the law is about those facts. There are no witnesses. The request is considered by a jury of 2 or 3 Queen's Bench Division High Court judges, although a Court of Appeal justice may be part of the panel in some instances. That method is only used against an indictment by the criminal, or against an acquittal by the court. It cannot be used to bring the statement into doubt. The challenge is because they say that the judges made the wrong decision because they made a mistake regarding the law. The Divisional Court can retain, change, or reverse the decision or remit, send back, the case to the Court of Magistrates for the judges to enforce the law judgment. There are usually less than 100 claims submitted each year by means of a case mentioned. Further appeal to the Supreme Court. The ruling of the Queen's Bench Divisional Court calls for the prospect of an appeal to the Supreme Court, previously known as the House of Lords, as a step further. An appeal of this nature can only be made. 1. The division believes and allows that there is a point of law that needs to be discussed by the Supreme Court, remember precedent. 2. The Divisional Court or the Supreme Court provides permission or leave to appeal since the issue or the point of law needs to be discussed by the higher courts, usually the Supreme Court. One result of a dispute pursuing the path of appeal was C. v. DPP, 1994. This case addressed the legal point on the assumption of children's criminal responsibility from the age of 10 to their 14th birthday. It had been accepted until this case that a child of this age could be convicted only if the prosecution proved the child knew he was doing wrong. The Divisional Court held that times had changed and that kids were more mature, and there was no need for the rule. They concluded that children of this era were expected to know the difference between right and wrong and that it was not appropriate for the prosecution to prove mischievous ability. The matter was then taken to the House of Lords, who overruled the Divisional Court, claiming that the statute was still that a person of this age was considered not to realize he or she was doing anything, and thus not to have the requisite motive for any criminal offense. Only if the prosecution disproved that presumption by bringing evidence to show that the child was aware that what he or she was doing was seriously wrong could a child of this age be convicted. That decision was based on the fact that it was up to Parliament, not the judiciary, to make such a significant change to the law. The tribunals have history required.